Today I'm going to talk about a case regarding Stillo versus the Toronto Transit Commission. This case is on the basis of duty to accommodate. The applicant alleges that the respondent failed to accommodate her disabilities in a timely manner, which led to undue hardship. The alleged failure to accommodate was when the applicant wanted to return to work after her knee surgery in August of 2015. Let's get into the facts of the case. Facts of the case. The hearing began in November of 2019 through March of 2021. 12 days in total were used in addressing this hearing during that time. The applicant was employed with the TTC since December of 2005. She was previously accommodated on behalf of her mental health disabilities between given permanent medical restrictions beginning of 2006 to 2007. The PMRs that pertain to the applicant were not working in isolated or secluded areas as a contingency of her mental health. The applicant worked as a yard control dispatcher upon her return to work in 2008, working the night shift. In December 2014, the applicant began a leave of absence due to a knee surgery, which ended in August of 2015. The applicant then began to experience sleep issues, which would affect her ability to safely perform her duties on the night shift as yard control dispatcher. Due to this, the applicant requested more accommodations. Facts of the case continued. The respondent took into consideration the applicant's sleep issues and provided ample opportunities for applicant to bid on other workplace positions in which the applicant was qualified for. The applicant did not apply to some positions as she stated she was not qualified. The applicant applied to a secretary position but was not awarded that position due to limited qualifications and experience. It was concluded that due to the applicant's physical and mental disabilities, there were no current roles available for the applicant to apply to during her return to work process. Arguments on behalf of the applicant. The applicant justified her accommodations by referring to her previous PMR of not being subjected to isolated or secluded areas. The applicant alleges that due to her previous PMR, her mental health disability along with her new sleep issues should have been known and accommodated in her return to work in August 2015, resulting in her not working the night shift. The applicant alleges that during the return to work process, she disclosed and provided medical notes that dictated her sleep disorders and that a sufficient role be provided for her. The applicant believes that there were opportunities available that she could perform, for example, maternity leave clerk positions, but that was not awarded. The applicant feels that the respondent shouldn't have requested further medical examination on her sleep disorder, as it was time-consuming and halted her ability to gain meaningful employment. The applicant believes the employer should have granted her access to the roles in which she was interested in. The applicant alleges that she did not know what the union could do for her in this situation. Arguments on behalf of the respondent. The respondent submits that during the return to work process, the applicant was placed in her previous position and was given accommodations based on her physical disability. The respondent included 3 witnesses in their arguments. One witness explained that due to the new issue of sleep, detailed medical notes would be required by sleep professionals to ensure that the company is informed of the reasons why the applicant could no longer perform the role she's been assigned since 2008. The respondent submitted that they accommodated the applicant's new sleep issues and tried to inform the applicant of new upcoming roles that would be deemed suitable. The respondent submits that they provided an opportunity for the applicant to be interviewed in a role that she desired. When interviewed, it was unsuccessful as the hiring manager felt she did not have qualifications. This role was given to another employee with qualifications and also in need of accommodations. The respondent also argues that as a unionized employer, they must adhere to strict policies and guidelines within their collective agreement to ensure that no human rights are violated. Hence, why they have worked so diligently with the applicant regarding her PMRs and new disabilities. Held. Ultimately, the tribunal believes that the applicant did not provide a prima facie or a credible argument that she was indeed a victim of an employer failing to accommodate. The Code. 11.1. A right of a person under Part 1 is infringed where a requirement, qualification, or factor exists that is not discrimination on a prohibited ground, but that results in the exclusion, restriction, or preference of a group of persons who are identified by a prohibited ground of discrimination, and of whom the person is a member. The employer made every effort to ensure the safety of the applicant and took into consideration her inclusion in the workplace by providing her tools, resources, time off, and opportunity for new roles within the company. 23. It is well established that an employer determines how an employee's restrictions and limitations may be accommodated having considered its business operations. The accommodation process requires cooperation. The applicant is required to make suggestions on behalf of themselves to ensure their accommodations, but ultimately it is up to the employer to ensure that these accommodations do not cause any undue hardship. Held continued. The tribunal used an applicant credibility test, which had been used in prior tribunal cases. These were the following: opportunities for knowledge, powers of observation, judgment and memory, ability to describe clearly what he has seen and heard, as well as other factors combined to produce what is called credibility. They also used Court of Appeal principles on trustworthiness. This was also applied. The definition is: testimonial evidence can raise veracity and accuracy concerns. The former relate to the witness's sincerity, that it is his or her willingness to speak the truth as the witness believes it to be. The latter concerns relate to the actual accuracy of the witness's testimony. The accuracy of a witness's testimony involves consideration of the witness's ability to accurately observe, recall, and recount the events in issue. When one is concerned with a witness's veracity, one speaks of the witness's credibility. When one is concerned with the accuracy of a witness's testimony, one speaks of the reliability of that testimony. Obviously, a witness whose evidence on a point is not credible cannot give reliable evidence on that point. The evidence of a credible, that is honest witness may, however, still be unreliable. Held. Applicant evidence lacking. The tribunal concluded that the applicant's evidence was not accurate, over-exaggerated, and evasive. The tribunal found that the applicant provided evidence and statements that contradicted her previous arguments. The tribunal had asked the applicant if she had any concerns about her return to work process, why she didn't contact her union representative. The applicant's response was that she didn't know what the union could offer her. She was not someone who sought out the union. This was concerning as the applicant had been represented by her union member in meetings with management, prior tribunal grievances, at which the applicant stated it was her union's job to protect her interests. This was a red flag to the tribunal, which began their questioning of evidence legitimacy, as it is clear she knew the role of her union representative. The applicant was then overheard on a break discussing the case and evidence with her husband, which she was given explicit orders not to disclose outside of the hearing. When asked about the details of the conversation, the applicant could not recall the conversation, which only happened minutes prior. Finally, when the applicant was to undergo safety training, the applicant complained of the excruciating pain she was in having to walk to the building due to her knee injury. The applicant used a cane as a walking aid, but never brought it to the training. The applicant disclosed that she never brought her lunch and would often go outside for lunch or smoke breaks, but did not complain about the walk to do that. The applicant did not take responsibility for her lack of preparedness in bringing her cane to training to assist in walking, but instead blamed it on the respondent for initiating the training in the first place. Ultimately, it was concluded that the respondent did everything they could to offer the applicant accommodations in her multitude of disabilities and PMRs regarding her work at TTC. Unfortunately, due to the applicant's unreliable evidence and evasive evidence, the tribunal did not find her evidence or arguments compelling enough to choose on her behalf. This is the conclusion of the Stillo versus TTC Toronto Transit Commission case. Thank you.